All right, so before we get into the substance of the presentation, we just want to present ourselves and our organization and give you a brief overview of what the clinic does. But before we get into that, we'd like to take a moment to acknowledge the ancestral lands the LICM is located on. The LICM is located on the traditional territory of the Kanakahaka and Anishinaabe nations, a place which has long served as a site of meeting and exchange amongst nations. We recognize and respect the Kanakahaka and Anishinaabe nations as the traditional custodians of the lands and waters on which we meet today. Who are we? So the LICM is the largest student-run legal clinic in Canada. We were founded in 1973 by law students at McGill. We are a nonprofit organization committed to increasing access to justice for the McGill and Montreal communities and to meeting the needs of students and marginalized groups because we believe that justice matters for everyone. And although we operate out of McGill, we are separate from the university. The clinic has 3 main branches, and all of our services are both free and bilingual in English and French. Our most well-known branch is legal information, after which the clinic is named. Under our legal information branch, the clinic provides answers to McGill University students and Montreal community members' legal questions. So if you ever have a legal issue or concern that you're dealing with, you can fill out an intake form on our website or call the clinic and leave a message. A caseworker will contact you shortly after to take on your case and answer your legal questions. However, it's important to keep in mind that because we are law students, we are not allowed to provide legal advice, only legal information. In other words, we can cite the law and explain the law to you, but we can't recommend any course of action or tell you what you should do. Also important to note is that we cover almost all areas of law, but we do not cover criminal law, tax law, or construction issues, and we can only answer questions that fall under Quebec law. However, if you have a question about one of the areas that we do not cover, or if the issue you are dealing with requires a service other than legal information, we are happy to offer referrals to community organizations that might be able to help you. In addition to answering legal questions, we also have a student advocacy branch that can support you if you have a dispute with the university. For example, if you are accused of plagiarism, you should contact them. They can advise you on what steps to take and represent you in any hearings with the university. You will be hearing about this branch in much greater detail in the last part of our presentation on student rights. Our other branch is community services. We provide 4 main services under this branch. First of all, we have a Commissioner of Oaths service. All the directors and senior caseworkers at the clinic are able to commission your documents for free, and we are offering this service remotely during COVID-19. So a commission is a sworn statement that the information contained in a document is true. This is required, for example, when you want to prove to McGill that you are a Quebec resident so that you can pay Quebec student fees. Second, we also provide a court accompaniment service where we accompany clients to their hearings at the Small Claims Court and the RÉGIE du Logement. However, unfortunately, this program is temporarily suspended since most hearings at these tribunals are currently occurring remotely because of COVID-19. Third, we provide just info presentations to McGill student groups or to Montreal community organizations in order to let people know their rights and responsibilities in a specific area of law. And we tailor these presentations according to an organization's needs. Lastly, usually in non-COVID times, 3 times a year, we set up legal information booths on campus for a Know Your Rights campaign to promote our services to students and help them learn more about their housing, employment, and student rights. However, since we all know that this year, at least for the summer and fall semesters, campus is closed, we are offering webinars like this one to students instead of setting up physical booths on campus. Before we begin the presentation, I just want to reiterate that in accordance with Article 128 of the Act respecting the Barreau du Québec, only lawyers and notaries can give legal advice in Quebec. Law students can only provide legal information. So nothing in the following presentation should be construed as or relied upon as legal advice. Today's presentation is divided into 3 sections. First, I will speak to you about your rights as a tenant in Quebec. Then Oliver will speak to you about your rights as an employee in Quebec. And lastly, Peter will speak to you about your rights as a McGill University student. In the end, we will have a Q&A session to answer any questions you might have about this presentation. So let's get started with residential leases in Quebec. This section of the presentation will cover the following topics. What is the Régie du Logement? Are deposits legal? Who can cancel a lease and when? Negotiating, transferring, and subleasing. And finally, which co-tenant is responsible for paying the rent? So the Régie du Logement is a special administrative tribunal that was created specifically for residential disputes, and it is responsible for hearing all disputes between tenants and landlords in Quebec. Tenants and landlords can open a file at the Régie for any of the reasons listed here. For example, if a tenant wants to file a complaint against their landlord because they are refusing to do a repair, they would go to the Régie, or if a landlord and tenant disagree about how much the rent should be, one of the parties could also go to the Régie to get the rent fixed. Usually, you would be able to visit the Régie in person to apply for a hearing if you have a dispute with your landlord. But right now, due to the COVID-19 pandemic, the Régie's offices are operating primarily remotely, with most of the hearings taking place over video conference. The Régie still maintains a telephone information service as well as their full range of services online, meaning you can still file an application for a hearing right now, but you do have to do it on their website. So now we'll use an example to talk about some of these principles in housing law. So Julia is a McGill student. She is originally from Toronto, but she is staying with her aunt in Montreal while she attends university. Julia still has a few years of study left to complete, and she would like to move into an apartment with her friends as of next September for the remainder of her studies at McGill. In January, with her two friends, Melissa and Camille, she agrees to sign a one-year lease that starts in September for the perfect apartment. However, when she is signing the lease, the landlord asks Julia for a security deposit. Julia is uncomfortable with this, and she wants to know what to do. So are deposits legal in Quebec? Should Julia pay the security deposit? The answer is no. The law in Quebec is very clear. A landlord may not ask a tenant for more than 1 month's rent at a time. The only payment the landlord can ask for in advance is the first month's rent. The landlord cannot ask for any form of deposit, so they can't ask for the last month's rent, they can't ask for a security deposit, or a furniture deposit, or a key deposit. So continuing with Julia's situation, in March, the university closed due to the COVID-19 pandemic. Julia went back home to Toronto to live with her parents for the remainder of the semester. Eventually, McGill announces that classes will be held remotely in the fall. In light of this announcement, Julia decides she wants to stay home with her parents for the fall semester. Can she cancel her lease, which starts in September? You may have heard that a tenant may break a lease at any point, either by giving 3 months' notice or by paying 3 months' rent. This is not true. Normally, the lease ends at the end of the fixed term, which in most cases is 12 months, if the tenant gives the landlord a notice of non-renewal at least 3 months before the end of the lease. This is because, in Quebec, residential leases are automatically renewed on the same terms unless the landlord has taken steps to change the terms or the tenant notifies the landlord that they are not renewing the lease. If the tenant wants to leave, they have to send their landlord a notice of non-renewal of the lease. Otherwise, they will be locked in for another year. Also, the landlord and tenant can, via mutual accord, end the lease at any time before the end of the fixed term. However, they do both have to agree on this. Otherwise, if they cannot come to an agreement, there are only a few circumstances in which the tenant can end the lease. First, if the dwelling is no longer habitable. So if it's not safe anymore for the tenant to live in the apartment, in this case, the tenant has to notify the landlord before leaving or at the latest within 10 days of leaving the apartment. Second, if the tenant must move to a hospital or a medical center or a low-income housing, notice in this case must be given 1 to 2 months before the tenant leaves. And finally, if the spouse of the tenant becomes dangerous and it is no longer safe for the tenant to live in the dwelling, notice in this case must be given 1 to 2 months before the tenant leaves. The landlord may terminate the lease under the following circumstances. First, if the tenant has not paid their rent for 3 weeks and is often late in paying their rent. Second, if the tenant hinders the peaceable enjoyment of their neighbors in the building. Third, if the landlord wants to repossess the dwelling for themselves or for a family member. And finally, if the landlord wants to make major renovations to the dwelling. These are the only situations in which a landlord may lawfully end a lease. In addition, the landlord must give the tenant 6 months' notice of an eviction, or they must apply to the RÉGIE before ending the lease. So can Julia cancel her lease due to the COVID-19 pandemic? As you might have noticed, none of the reasons I listed for ending a lease address the current pandemic situation we're living in. And some of you might be wondering if the COVID-19 pandemic is a legitimate reason to end the lease. Well, it's complicated. Many have been wondering if the pandemic counts as a force majeure or superior force in Quebec, or in other words, an event that is beyond your control that makes it impossible to fulfill a contract. Whether something counts as a force majeure is decided on a case-by-case basis, but it is generally a very high bar, and it only applies if it is truly impossible for a contract to be fulfilled due to an unforeseeable event. For example, COVID-19 might be considered a force majeure with regards to having to cancel the reservation of an event space for a wedding, as it is now prohibited by law to gather in large numbers indoors, and it is therefore no longer possible to host a wedding. But it would likely not be considered a force majeure with regards to the sale of a home, as it is still possible to buy and sell a home. When it comes to a lease, it is still possible for Julia to fulfill her obligation to pay the rent, regardless of whether or not it's possible for her to actually live in the apartment. As long as Julia's landlord has fulfilled their obligation of providing her with the peaceful enjoyment of the premises, she will be expected to pay rent in return. The important consideration when it comes to an unforeseeable event like COVID-19 is whether the performance of the contractual obligation is impossible. It is still possible for Julia to pay rent during COVID-19, so she cannot end her lease for this reason. So then what are Julia's options? Julia now knows that the COVID-19 pandemic is not a legally valid reason to end her lease. However, she still wants to stay in Toronto for the fall, and she would prefer not to pay rent for her apartment in Montreal. What are her options? The 3 options available to Julia if she does not want to pay for the apartment in Montreal while she stays in Toronto are: first, negotiating with her landlord; second, assigning the lease, commonly referred to as a lease transfer, and third, subletting. So negotiating with the landlord is a first step that may allow the tenant to avoid more complicated processes. While it is difficult for a tenant to end a lease early without the landlord's consent, it is possible to end one's lease if both parties, so the tenant and the landlord, agree. Thus, depending on the tenant's relationship with the landlord, it might be possible to negotiate an early termination of the lease. If this is not possible, the tenant might want to assign the lease. Assigning a lease, or a lease transfer, means the person you assign the lease to takes over all rights and responsibilities of the lease, including paying the rent. If Julia wants to assign her lease, she will need to find someone who wants her lease, and then she must send a notice to her landlord letting them know who that person is that's taking over. Julia's landlord has to respond to her notice within 15 days and can only deny the assignment if they have a serious reason for doing so. For example, if they are seriously concerned about the new tenant's ability to pay the rent. If the landlord does not respond within 15 days, the assignment is presumed to be accepted. A step-by-step guide can also be found on the McGill housing website for how to assign a lease. If Julia does not find someone to assign her lease, or she plans on moving back to Montreal for the winter semester, she can sublet. For example, she could sublease her apartment from September to December if she wants to move back in January. Subletting is a temporary arrangement, meaning Julia still stays on the lease and has a right to return to her apartment when the sublease agreement ends. But it also means she is still responsible for rent in the case that her subletter does not pay. If Julia wants to sublet her apartment, as with the lease assignment, she must send a notice to the landlord. And, just like a lease assignment, the landlord has to respond within 15 days and can only deny the sublease if they have a serious reason for doing so. Since a sublease is a new contract, the tenant can offer terms to the subletter that are different from the ones in their own lease contract. For example, a tenant could lower the rent they charge their subletter, but they would then have to cover the difference themselves to their landlord. However, they cannot give any rights to the subletter that they themselves don't already have. So an important thing to note here is that a landlord cannot add a clause to a lease saying that sublets or lease assignments are not permitted. It is your right to be able to assign your lease. Even if the landlord puts one of these clauses in the contract, it is not valid and it will not be recognized by the courts. So is Julia responsible for her co-tenant's rent? Julia, unfortunately, was not able to find someone else to assign the lease or sublet to. After discussing the situation with her parents, she has decided to go to Montreal in the fall and move into her apartment. However, both Melissa and Camille have told Julia that they won't be staying in the apartment in the fall and that they don't plan on paying the rent or finding people to assign their lease or sublet to. Julia is worried that the landlord will make her pay for the entire apartment's rent, which she cannot afford. So tenants need to read their lease very carefully to know whether they might be responsible for their co-tenant's rent or not. If it is not specified in the contract, the tenants will by default have what is called joint responsibility for the rent. This means that each tenant is only responsible for paying their share of the rent. However, if the lease specifies that the tenants are solidarily liable for the rent, each tenant will be responsible for the entire amount of the rent. But regardless of how the responsibility is shared, for one of the tenants, if one of the tenants ends up paying the entirety of the rent, they can always require that the other tenants pay them back for their shares of the rent. So is Julia responsible for her co-tenant's rent? Well, it depends. Julia must read her lease carefully to see if she and her co-tenants are jointly or solidarily liable for the rent. Regardless, if Julia were to pay for the entirety of the rent, she would still have the right to ask Melissa and Camille to reimburse her. In a standard lease contract, which is most commonly used in Quebec, a co-tenant can find out if they are jointly or solidarily responsible for the rent by looking at section H of the form. So you can see that we've included section H on the presentation here. So in the part that we've highlighted in red, it says the lessees undertake to be solidarily liable for the lease. So if you check yes, this means that you will be responsible for your co-tenant's rent or your roommate's rent in the event that they don't pay. If you check no, you will each be responsible for your share and only your share. If you don't check anything at all, the law presumes that you said no. So when you are signing a lease, you need to be very careful with this, and you need to think about whether you want to be responsible for your roommate's rent or not, and decide which box to tick. So that's all for today on tenant rights. I hope the information was helpful to you. And now I will pass it off to Oliver, who is going to speak to you about employment rights.
Thanks, Emily. So hello, everyone. I'm going to be presenting the employment law section of this presentation. And this section will be divided into 5 parts. First, I'm going to be speaking about working as an international student. Then I will be speaking about what to look out for in the employment contract before jumping into the rights and obligations that arise between basically employers and employees. Afterwards, I'm going to speak about human rights in the workplace, speaking about questions of discrimination. And then I'm going to speak about the end of the employment relationship. So I will now get started. So I will basically start the section about working as an international student by presenting a bit of a scenario. So Sam is an international student who just finished his first year at McGill, and he's getting ready to spend his first summer here in Montreal. Sam didn't consider working during the school year because he was quite busy with his studies, but he's thinking about finding a job related to his field of study for the summer. He is wondering if he's eligible to work in Quebec as an international student. So, the first important point to set out is that international students cannot work before they begin their studies unless they have a valid work permit, which is basically an authorization to work. With that being said, though, after their studies end, international students can work in basically 2 scenarios. The first scenario that's set out is if the international student already applied for a work permit or a postgraduate work permit before that study permit expired, and in addition, they were already able to work off campus during their studies. The second scenario is if the international student is starting a new study program and they meet the following requirements. First, they were already able to work off campus during their previous studies. Two, they have a valid study permit, or they applied it to end their to extend their study permit before it expired. Three, they received written confirmation from their current school that they've completed their program. Four, they received a letter of acceptance to a new full-time study program at a designated learning institution. McGill is on this list, which can be found online on the Government of Canada website. And five, they start their new study program within 150 calendar days of receiving that confirmation that they completed the previous program. So now I'm going to speak a little bit about internships and co-ops and on and off campus work, which are the ways that one can work during the course of study. So I'll kick things off with internships, which are included as a part of the curriculum of some study programs. International students enrolled in those programs can apply for a co-op work permit if, one, they have a valid study permit, two, the internship or co-op work is required in order to graduate from the program, and they have a letter from the school that confirms this fact, and three, the internship or co-op placement accounts for less than half of the credits of the study program. That being said, even if they meet those above requirements, international students enrolled in one or more of the following courses cannot apply for a co-op work permit. One, an English or French as a second language course, so ESL or FSL. Two, general interest courses, which are defined as courses outside their program of study. And three, courses to prepare for another study program. But even if you were to be enrolled in one of these courses, you are still entitled to apply for a regular work permit. It really just means you cannot apply for an internship or co-op work permit. So the difference between on-campus and off-campus work might seem intuitive, but I will sort of try and canvas the differences between the two anyway, because there are some nuances. So an international student can work on campus without a work permit if they meet the following conditions. First, they have to be a full-time student with a valid study permit at a public or private, like CEGEP, college or university in your cases. And they are not on authorized leave. Two, they need a social insurance number. And if you happen to need one, if you need to apply for a social insurance number, I should say, an international student must have one of the following conditions listed on their study permit. They're currently up on the screen, but the key would basically be to look at Regulation 186 of the Immigration and Refugee Protection Regulations. So I'll let that sort of stay on the screen for a little bit. And if none of the above conditions happen to be present on the study permit itself, but the international student meets the other requirements for either on-campus or off-campus work, which I'm about to speak about, they can actually just request the Canadian government to have one of those conditions added to their permit for free. So if it's not already there and you happen to meet the other conditions for work, then you can request a change to your permit. So, but what does on-campus actually mean? Well, it means that an international student can work at all the buildings that are located on the campus they study on. So why is this important? Well, for example, if Sam attends McGill's downtown campus, in most cases, he won't be allowed to get a job at Donald campus, which is located to the west of the island. If they're a research assistant or their work is strictly related to a research grant, an international student can work at other locations associated with the school that are off campus. So that could include like a library, a hospital, or a research facility, etc. In terms of what can constitute an on-campus employer, we can think about the school, a faculty member, a student organization, a private business located on campus, a private contractor that provides a service to the school on campus, or even yourself if you happen to run a business that is physically located on campus. By the way, for questions, I'm so sorry, guys. I'm going to basically roll the questions right at the end, and we'll sort of address them top down. So in terms of off-campus work, what are we talking about now? Sorry about that. Basically, an international student can work off-campus without a work permit if they meet the following requirements. One, they are a full-time student with a valid study permit, enrolled in an academic, vocational, or professional training program at a designated learning institution, and they are not on authorized leave. One exception to this rule is that a student can be part-time if they're in their last semester. So I would keep that in mind for later on. Two, the program they're enrolled in is at least 6 months long and leads to a degree, diploma, or certificate. Three, they are not only enrolled in an FSL or ESL program, taking general interest courses, or taking courses to be accepted into a full-time program. And four, they need a social insurance number. So now I'll jump to hours per week that Sam can work for. So here is the scenario. Sam looked at the conditions on his study permit and realized that he was eligible to work off campus this summer without applying for a work permit. He applied for and obtained a social insurance number, and he's now on the hunt for a job, but he's not sure if he can work full time. So how many hours of work can one work for? Sorry, am I frozen? Oh, we're good. So if they have an internship or co-op placement, they can work the number of hours that's basically set out right on the work permit itself. So for internships and co-op placements, it's easy. If they are working on or off campus without a work permit, they can work up to 20 hours per week during school and full-time during school breaks, such as the winter or summer holiday or the fall or spring reading week. And then finally, there is no set number of hours per week that counts as what's full-time work. However, the employer must follow all provincial laws on overtime pay and time between shifts. So I will now be speaking about basically the second section of this presentation, which is going to go a lot faster. That first section was quite long. Sorry about that. So now we're going to speak about what to look out for in an employment contract. So the scenario is that Sam now knows that he can work full-time this summer. After a few interviews, he managed to find a job related to his field of study. It's his first serious job and the first time he will work in Quebec. So basically his new employer sent him his contract by email and expects him to review and sign it. Sam has never read an employment contract before and is unsure what to look out for. So here are some of the basic rights that are protected by the Act Respecting Labor Standards. This is a little bit of a mix. So first, an employee is entitled to a minimum wage of $13.10 an hour. There is an exception for employment in restaurant services, seasonal harvesting, hotel industry, etc., which has a minimum wage of $10.45 an hour. This is commonly referred to as a tip wage. The second is one is entitled to have their training paid for, so to be compensated for the time spent training. Third, if an employee is working for minimum wage, the rule is that the employer has to supply any special clothing required free of charge. However, if the employee makes more than minimum wage, the employer can deduct a certain amount from the employee's salary to pay for the uniform. But that amount deducted must not reduce one's salary to an amount below minimum wage. This is crucial though. Additionally, when the clothing you wear to work identifies you as an employee of that business, the employer must provide it for free, regardless of what one's salary is. So we're talking about like branded clothes. Finally, after 5 hours of work in a row, sorry about that, an employee is entitled to a meal break of at least 30 minutes, but the employer does not have to pay them for that meal break. Additionally, the law does not oblige employers to give coffee breaks, but employers who give one must pay employees for this time. An employer can decide the length of a coffee break. So now I'm going to speak a little bit about rights and obligations that arise between employers and employees. So Sam signed his contract and sent it back to his new employer. Now that he's employed, he is wondering what rights and obligations he has during the employment period, other than the ones directly referred to in the contract. So some of the employer's obligations that are quite important are listed up on the screen. Namely, an employer is required to protect employees' health, security, and dignity. They must allow the execution of the agreed upon tasks, as well as pay the agreed upon salary and wage. They also must provide a clear and explicit employment contract, and they must respect the Act respecting labor standards in terms of sick leave, and then maternity and paternity leave, etc. In terms of an employee's obligations, an employee must act with honesty and fidelity, must do their work prudently and diligently, they must be able to execute the agreed upon tasks, and they must not use confidential information obtained during their employment. So in terms of whether or not an employer can discriminate or not, this is part of the human rights section of the presentation. So Sam's friend Jonathan would like to get hired as a driver by the company that Sam works for. However, he told Sam that a few years ago, he was charged and convicted for driving under the influence. Jonathan is worried that the company will refuse to hire him because of his criminal conviction. Sam tells Jonathan he doesn't think the company is allowed to do that because it'd be discriminatory. But is Sam right? Well, up on the screen here are the grounds listed that are protected from discrimination in the employment context. Important ones to note include like race, color, sex, language, religion, pregnancy, among many others, civil status as well. But in addition, an employer is prohibited from dismissing, refusing to hire, or otherwise penalizing an employee on the sole basis that they were convicted of an offense if the offense is in no way related to the employment, or if the person received a pardon. One should be aware, however, that a distinction, exclusion, or preference based on the aptitudes or qualifications required for the job is not discrimination. So how about Jonathan? Can Jonathan be denied employment because of his criminal record? Well, in this case, Jonathan is applying for a position as a driver, and he was charged and convicted with a DUI, and he has not received a pardon. So the company may thus refuse to hire him solely on this ground. So finally, I'm going to be speaking about the end of the employment relationship and specifically about wrongful dismissal. So the scenario is as follows. Sam's employment contract specifies two things. His employment is for a fixed term of 4 months and that he is entitled to 7 days of vacation. However, when Sam signed his contract, his boss told him that he would prefer if Sam did not use his vacation days because the department that Sam works for is going to have a lot of work this summer. Nonetheless, halfway through the summer, his boss told him that he was letting him go because he felt that Sam was clearly not working hard enough since he took his vacation despite being told not to. Sam wants to know if his boss can fire him for using his vacation days, and he also wants to know why he wasn't given a notice of termination. So can Sam's boss dismiss him for taking a vacation? No, the law is pretty clear. No employee can be dismissed for having exercised their rights, such as going on sick leave, going on pregnancy and or maternity, paternity leave, taking a vacation, etc. Right? But since Sam has been employed for less than 2 years, he doesn't have recourse for what's called wrongful termination against his employer under the Act respecting labor standards. The ARLS, for short, only protects employees who have worked for the same company for 2 years or more from wrongful termination. Employees who have worked somewhere for less than 2 years are protected by the Civil Code of Quebec. However, under the Civil Code, Sam's only recourse against his boss is a civil lawsuit, which can be kind of expensive, and since, unlike when you file a claim under the ARLS, a lawyer is not provided to you for free. A less expensive option for Sam would be to file a claim against his employer for prohibited practices under the Act respecting labor standards. This recourse ensures that no employer can impose a sanction, like dismissal, on an employee for exercising their rights, like the right to take a vacation. And sort of as a bonus, one is allowed a lawyer for free from the SINEST, which is the tribunal. Finally, why did Sam's boss not give him a notice of termination? So basically, it's because Sam has been at his job for less than 3 months, and as you can see from the table of this slide, this means that his employer doesn't have to give him a notice of termination before dismissing him. This is also the case for an employee with a fixed term contract when that fixed term comes to an end, and employees that are dismissed for serious fault. So that concludes employment, at least this part of the presentation, and I'm going to be passing it off to Peter to speak about student rights. Thanks for listening to my section.
Thank you, Oliver. So I'm going to be talking to you today about student rights and how student advocacy, which is kind of a separate office from the Legal Information Clinic, deals and helps you as a student. And we're going to be kind of going over just a quick outline of the different rights that you have. So we're going to be going over what student advocacy is and how it can help you, what a grievance procedure is, what are some of your rights as a student, and what happens if you get accused of a disciplinary offense. So if you get accused of plagiarism or something like that. So student advocacy has been part of the LICM for over 30 years. And, but we don't necessarily have something where it's like, oh, what do we do, right? So we represent and help students who have problems with the university and have issues with, you know, anyone from other students to administrators. So our office consists of a variety of different people. There's me, I'm the Director of Student Advocacy and University Affairs. I supervise the office and I help manage everything within it. There's my team of senior advocates who manages our junior advocates and assists the director. In the event that you ever had a case, you'd probably be meeting with me or one of the seniors to kind of take in your case and learn about the details that the issue that you might be having. And then we have our junior advocates who are usually assigned to you and will be the ones representing you and advocating on your behalf. So what specifically does student advocacy do? We advise, we represent, and we negotiate on your behalf for students who are facing disciplinary proceedings or having difficulties with the university. So you might be asking yourself kind of from that, you know, what's our difference between, you know, the information I'm going to be giving you versus the information you just received from Oliver or Emily? Well, we're allowed to provide advice. So we can provide advice on McGill policies, such as the Code of Student Conduct and Disciplinary Procedures, the Code of Student Grievance Procedures, harassment, sexual harassment, or discrimination. And within most of these McGill policies, they actually provide for you to be represented by an advocate or somehow receive advice. But it's important to know that we can't provide you any information that would constitute legal advice or information. So everything, say, related to employment, we couldn't really talk about that. But we can help you if you have an issue with a McGill policy. So there are also a variety of other policies. The ones I mentioned earlier, like the Code of Student Conduct, are the ones that you're probably going to most commonly encounter, but we also deal with other issues within McGill. I'm not going to go through the whole list, but some of the more common ones include the policy concerning the rights of students with disabilities, the policy on intellectual property, the policy on harassment and discrimination prohibited by law, the policy against sexual violence, and the university student assessment policy that covers things like grading. And our advocates, they can normally appear at a variety of different locations. So, you know, we have disciplinary interviews. That's something that we're going to be covering more later. So that's in the event you're ever accused of plagiarism or something like that. We can also represent you at the Committee on Student Discipline Hearings, which is more serious, for more serious allegations related to that kind of area. We also represent students at appeal hearings. So in the event that you're unhappy with the decision that's made at one of those various hearings. In the event, say, that you're entering the Faculty of Medicine, we can represent you at faculty promotions committees. Similarly, we have grievances, which we'll be talking more about later, when you have an issue with other individuals or, say, a policy and the way it's being interpreted at McGill. And then we also help students when they have just a general dispute that they need a resolution to. So in the event that you and your supervisor are not getting along, say for you know, a PhD program, we'd be able to accompany you to that meeting and do our best to help try and mediate. So you might be asking yourself, what is a grievance? A grievance is a formal process by which a student can seek redress for an infringement of their rights by another member of the university. So in the event that somehow, you know, you felt that your rights as a student have been one way or another impacted by, say, a professor or another student, but these grievances have to be grounded in the Charter of Student Rights. So one of those different articles within the Charter needs to be able to be pointed to and to say, this is what was violated, this is where the issue is. Any student who believes they've had a right that's been infringed by a member of the university community has this ability to lodge a grievance. And this infringement can either be from an act or a failure to act. So in the event, let's say a professor decides to do something, but also in the event that the professor fails to do something on your behalf. Former students are also allowed to lodge a grievance so long as the violation happened while that person was a student. The only limitation is that it has to be within 2 years of you graduating. So in the event that you remember from this presentation that this is an issue and you go through your entire degree, and then when you graduate, you realize that maybe there was an issue you wanted to bring up, you can still come to us and we'd be help you be able to file that grievance. And because this is kind of a very complex process and that there's a lot of different elements on what can and cannot constitute as a grievance, don't be afraid to come to us if you have questions. You can always reach out by email, which we'll be including it at the end. And in the event that you ever want to pose private questions as well, don't be afraid to reach out to there as well. But we'll get more to that later. So you might be asking yourself, what are some of your rights as a student? The Charter of Student Rights outlines several rights, but it's important to emphasize that this list is not exclusive. This is just some of the more common ones that we might be referring to. So you have a right to equal treatment. You have a right to be free from vexatious conduct or violence. You have a right to quality education. You have a right to fair and reasonable evaluation. You have a right to adequate graduate supervision. You have a right to full, equal, and fair hearings. You have a right to consult any record of personal information. You have the freedom of association, and you have freedom of opinion, expression, and peaceful assembly. It's also important to note that some of those other policies that I referred to earlier have their own specific rights. For example, in the Code of Student Conduct, you have the right to be represented by the advocate. You also have a right to not speak at a disciplinary interview if you choose not to. So in terms of common misunderstandings, the list that I have there just gives you an idea of what sometimes people can assume will happen if they get a student advocate to represent them. But the fact of the matter is, most of the time when we're involved, we can give you advice only about the policy related to McGill. Generally speaking, we can help you speed up the process if you're not hearing anything from the various university officials that you might be interested in contacting. We do our best to try to find a way to solve the issue before, say, going to a grievance. We do want to do our best to make sure that you get a satisfactory outcome as quickly as possible. It's also important to note that being represented by us is not something where you're going to be punished for it later. Some students worry that having our representation, say at a disciplinary interview, implies that they look guilty. That's not the case at all. And by us advocating on your behalf, you're allowed to have us by that position, in the interview to represent you. It's also important to note that we do not have the same standard as, say, like a lawyer. So you do not have a solicitor-client privilege when we represent you. However, we'll get more into it later, but everything you do provide us is 100% confidential. So you might be asking yourself, what happens if you get accused of a disciplinary offense? And here I'm going to go through just an example to give you a bit of an idea. Jemma is an international student in first year taking a history course. She's required to write a paper as one of her assignments. While writing it, Jemma copies some of the sentences directly from a textbook. After submitting the assignment, she receives an email from her faculty asking her to attend a disciplinary interview based on a violation of Article 16A, which is plagiarism, of the Code of Student Conduct and Disciplinary Procedures. So you might be asking, what should Jemma do? Well, the first thing she should do is reach out to Student Advocacy at the LICM. Often, disciplinary officers or the email the OC will even encourage you to reach out to us, but that's something that you should immediately do so we can provide you with guidance. We guarantee confidentiality in that all of our cases are kept completely confidential within our office. All of our advocates are required to sign a code of ethics to work with students. And that advocate assigned to your case can only discuss it with either me or another one of the senior advocates to get further advice on how to proceed. So at that point, Jemma is asking what would happen next. She's reached out to Student Advocacy. A junior advocate has now been assigned to her case, and she asks her advocate what will be occurring. So as you're about to see, this is a very complicated chart that gives you an idea of all the different directions a disciplinary offense can take. I'm not going to be going into every single possible outcome, but what we're really going to be focusing on here is a disciplinary interview, which is the most common, and the different paths that occur from there. But it's important to note that your case can take a variety of different turns depending on kind of what occurs. So now that Jemma's student advocate has explained the process of a disciplinary offense accusation to her, she's a little bit less nervous about attending her disciplinary interview, but she's still wondering how she should prepare for it. She asks her advocate what will happen during the interview and all the different outcomes possible from there. So a disciplinary interview usually includes 3 people. There's the disciplinary officer, there's the student who's been accused of a disciplinary offense, and if they choose, accompanied by their student advocate. Sometimes there might be a 4th person there who would be the disciplinary officer's advisor. That could either be the professor who, say, is accusing the student of plagiarism. It can also be someone who's there to take notes and to just help assist in the interview. The disciplinary officer, once the meeting begins, will inform the student of their rights, so their right to remain silent, their right to have an advocate present. And then at that point, they will present the evidence and they'll ask the student to speak. So it's important to note that the disciplinary interview process is not like going to court or something like that. It's a very informal process that's more of a conversation that allows the disciplinary officer to try to understand the narrative of events and either understand where there could possibly be a misunderstanding or understand why this occurred. So there are 3 major potential outcomes from a disciplinary interview. The first one is an exoneration, which means that there's not enough evidence in order for a person to be found guilty of committing a disciplinary offense. The next one that's most common would be an admonishment, which means that there is sufficient evidence of an offense. However, it's only an official sanction, not something that is on your disciplinary record. So in the event that, say, you're applying to do a PhD or another program down the road, no one will ever see that. That's only internal to McGill in the Office of the Dean of Students, and it's only relevant in the event you're accused of a second disciplinary offense. The third option is a reprimand, which again is another finding that there is sufficient evidence that a disciplinary offense was committed, and it is an official sanction that is on the record. However, it's important to note that that record is confidential, and it can only be revealed in the event that you give consent for it to be revealed. So in order for there to be sufficient evidence, the evidence is reliable. That's the standard within the Code of Student Conduct in order to result in either an admonishment or reprimand. And that's important to keep in mind so that when an advocate is taking a look at the evidence with you, they'll be able to kind of explain whether or not the evidence reaches that threshold. So you might be wondering, what's a likely outcome of Jemma's interview? It's important to note that given the vague situation that I kind of explained, there's a lot of different possible outcomes. But based off of what I was giving you there, it's most likely that she would be admonished, depending on exactly what was plagiarized and what occurred. But Jemma's also worried about additional penalties, not just the disciplinary record. So she asks her advocate whether or not that's a possibility and what those would look like. So additional penalties can include, first off, conduct probation. So that just means repeated, in the event that you repeat the disciplinary offense, you would be held to a much higher standard the second time. This is very common in the event that you are found guilty of committing a disciplinary offense. Some of the other ones listed here are more for, say, an offense committed while in residence. So an example would be the 10 hours of unpaid non-academic activities, or security for good behavior exclusion for residents from a specific time. Suspension might be applied in the event of a disciplinary offense such as harassment, which is Article 10. These aren't necessarily the most common. The most common for, say, something like an academic offense might be failing the assignment.
Sorry, Peter, I'm frozen 1 sec. Oh, jeez. There we go.
Okay. No worries. So you might be asking then, what's the likely outcome for Jemma? It's likely that she'll be put on conduct probation. That one would be standard. And it's also most likely that she would receive a 0 on the assignment. And it's important to note that in the event that that assignment is mandatory to pass the course, she could also fail the course. So that's all depending, though, on specifically what was committed. And you have to keep in mind that it is very much dependent on what you're being accused of and what the evidence is. And that kind of concludes a brief idea of what your student rights are. And it's important to emphasize that they really are broad. And in the event that you're ever worried about anything, you shouldn't be afraid to kind of reach out and contact us. Here's all our information for our contact info. I really want to bring attention to the info.studentadvocacy@licm.ca. So if you ever have a question related to student rights, don't be afraid to email there, and we'll do our best to help you out there. And if you have any other kind of legal information question, don't be afraid to take a look at the legal information number. And we're happy to answer some questions here if you have some related to, your rental, employment, or student rights. And thank you for listening.
Thanks, everyone. So now we're going to jump into a bit of a question and answer period. So at this point, we're going to stop recording, and we are going to stop sharing the screen.